Did you know that Judgment Day is here? Well, in fact, Judgment Day was June 6th of 2024. Now, what's that all about? Well, here's the problem. The Supreme Court agreed with the IRS on that date that business-owned life insurance is now considered a business asset. And that business asset from the insurance death benefit increases the value of a business at an owner's death. So, in the nearly 30 years I've been advising business owners, life insurance benefits have never been taxable. So this is brand new, and it impacts a lot of businesses and their ability to successfully survive a business owner's death. Now, why does that matter to you? Well, if you're a business owner, probably quite a bit. Here's an example of a business we're working with right now. So you can see here, this business is valued at $10 million, and there are 4 partners. And you can see the percentages of ownership there. And now the 50% owner, that person should be a 51% or more owner. That's another video for another day. But this is the ownership currently of this particular business. And you can see on the right-hand side, the corresponding life insurance death benefit values and how they match up with the ownership of the business. And then the other thing that you want to take note of is at the bottom, the business is both the owner and the beneficiary of these policies. It makes it very simple. It's been the way we've done this for decades and decades. And so let's look at slide number 2. You can see here that with the Supreme Court case that just took place, because this life insurance is now an asset of the business at the death of an owner, if all 4 of these owners died at the same time, that business value would jump from $10 million to $20 million. So this is an important distinction. This was never the case before. What happened previously, when a business owner died, their life insurance was used by the business who owned the life insurance policy. That cleared the debt of whatever was owed to that person's spouse or their estate as a business owner. It was always considered a way to clear a debt. But now the IRS convinced the Supreme Court, in fact, convinced all 9 justices. So this is the Supreme Court that was unanimous in their decision that this is a business asset now as opposed to a way to take out a liability. Okay? So last thing that I want you to take a look at here is the biggest issue with this is, for the business anyway, this creates a liquidity crisis. Okay, what do I mean by that? Well, this business, instead of being able to use this insurance to buy out the deceased owner and be able to function as a business without taking on maybe an unwanted partner, now they're scrambling. Because in this particular case, this $5 million of insurance was added to the $5 million of ownership. So now they need to come up with $10 million, or essentially another $5 million. So that might need to be borrowed from the bank. They might have to sell assets. Maybe these business owners don't have the cash flow. So now, instead of selling the business or basically declaring bankruptcy, maybe they can't take a salary for the next couple of years. Imagine how that's going to impact their families. So this is a really big deal. You can see, what's the big deal to the owner who's passed away? Well, he's gone, so that's bad, right? But secondarily, his family is going to end up paying a lot more in personal income taxes because his value or ownership in the business doubled overnight. And then secondarily, or in addition to that, the estate tax on that sale of that portion of the business is likely going to increase. So this is a huge problem in multiple ways. Now, why did this happen? Well, there were a couple of brothers down in St. Louis who were the plaintiffs involved in this case, and they had a succession plan and they had life insurance, but they decided to ignore their governing document for their plan. So the succession plan, sometimes we refer to that as the governing document. So because there were millions of dollars involved, the IRS started poking around. And the last thing you want to do is have the IRS involved when there's millions of dollars at stake. So if you'd like to read more about this, in the July 13th and 14th edition of the Wall Street Journal, they have it covered pretty well. Laura Saunders, who wrote the article, does a really good job of explaining the details of the case. So I'd encourage you to read that article as a complement to this video so you can understand the circumstances a little bit better. So if you didn't know about this case, you're not alone. Most attorneys and CPAs are not aware of this rule either. Now, we've been talking to our clients about this rule since June 7th, and their legal and tax advisors that we were bringing in to help us work through the details and how we were going to fix things, they hadn't heard about this until we brought it to their attention. So, what do you need to do? Well, first, do you have a succession plan in place? If not, well, then you're like a lot of other business owners because they don't have one of these in place either. Make it a priority in 2024 to get your business succession plan written out and completed and documented. Now, if you're struggling getting started, give us a call. We can help you do that and maybe get you some resources that are available or that we've made available to our clients to kind of help you get jump started. Secondly, if you do have a succession plan, do you know where that document is? Is it in the bottom desk drawer down here? Is it in the filing cabinet over there? Is it in the safe at home? Do you know where it is? Can you find it? And then once you found it, do you know what it says? Have you read through it? Especially if you did it 5, 6, 10 years ago. Does this plan, or governing document as we like to call it, does it fit what you're doing today and the ownership of today? And is it flexible and fit where you're going tomorrow for the business? And then lastly, do you have life insurance and disability insurance that covers you or the other owners as part of this agreement? Or did you forget or maybe put that off too? Okay, well, now's the perfect time to get going on this before things get worse. What could get worse? Well, your health and the tax code. So this is the time to get serious about putting a plan of action in place. And the tax, just as a reminder, the Tax Cuts and Jobs Act of 2017, or AKA the Trump tax cuts that you hear so much about, well, they're set to expire on December 31st of 2025. So personal tax rates are going to spike. And the estate tax exemption, that's going to get slashed by 50%. So the client in the example I just shared, and actually I'll bring that back up on the screen. So this majority client or shareholder, or this majority shareholder that's a client, right now, based on his circumstances, if he were to die today, he'd owe about $800,000 in estate taxes. Okay? But if we fast forward to 2026, even if his business did not increase at all in value during that next 2 years, his estate taxes are going to jump from $800,000 to $2 million once this life insurance death benefit gets brought back into the business if we don't get this fixed. Totally crazy, right? So do you know how this decision, frankly, that favors the IRS, do you know how that impacts you and your family? Do you know how it impacts your company? You need to be reaching out to your advisors if they are not proactively reaching out to you. Make this a priority for your business this month to determine how Judgment Day impacts your business. Otherwise, my team at True Wealth Stewardship, we're here to answer the tough questions and help you figure out what to do next.